Okay, so hello everyone. Welcome to the Federman Cyber Workshop. We are delighted to host with us Professor Marko Milanovic, one of the most leading and influential voices in the study and research of international law today. Just to name some of his achievements, and this is really the tip of the iceberg. Professor Milanovic, other than his position as Professor of International Law at the University of Nottingham, is co-editor of Eagle Talk and is a member of the editorial board of the European Journal of International Law. As he just mentioned, As he just mentioned, he is one of the 3 high-level experts which were appointed by the UN High Commissioner of Human Rights to assist her in investigating human rights violations in Belarus since May 2020. In addition, Professor Milanovic also represented states before the International Court of Justice. My cat wants to join the presentation, Marko. I hope you like cats.
Cat is very pleased about the new budget for the cats. Did you hear that? There was a 12 million shekels approved for cats.
But he's not enjoying it. He's domesticated.
Okay.
In addition, Professor Milanovic represented states before the International Court of Justice, and in our context, he is the co-general editor of the Tallinn Manual version 3.0. It is wonderful to have you here with us, Professor Milanovic, and we look forward to hear your presentation on intelligence sharing in multinational military operations. The floor is officially yours.
Well, thank you so much. It's such a great pleasure to be with you all today. It's a shame we couldn't all be together in Jerusalem, but have to do it on Zoom. I really am tired of Zoom. I imagine all of you are as well, but soon, hopefully, we will be rid of it. I'm very grateful to you for the opportunity to talk about this paper. The paper is more, as you were saying, really a short book. So it's very long, it's 60,000 words. There is no expectation that any of you will have read it or will read it. It was part of a project that I had that was funded by the British Academy. And the paper was published in International Law Studies at the US Naval War College. And the topic is not strictly cyber, but it is cyber-ish. I mean, it's like tangential to cyber in a sense, and it's really about intelligence sharing. The intelligence could be something that a state obtained through cyber and is sharing electronically, obviously, right? And in that sense, that's the link with cyber, but it could also be an item of information that was obtained, for example, in the interrogation of a person who was detained. So not something that is directly cybery, you see what I mean? So I was really interested in how international law would apply to these problems of intelligence sharing, and in one particular context, because states share intelligence all the time in various contexts, including in peacetime. So the United States and Israel, for example, Israel and the UK, whoever, will be cooperating all the time on various criminal investigations, on various intelligence activities with regard to, I know, Iran, to pick a random example, that are not necessarily as part of a military operation. But once there is such an operation, states will inevitably share information with their partners. Sometimes they will be partners that they really like. Sometimes they will be partners that they wouldn't have dreamed of cooperating, but of necessity have to. So I recently did a much more digestible version of this article for Eagle Talk in a series of 4 posts that were published this week and last week. And I opened the first post by an example that would have been very science fiction-y, almost, even a few months ago. And this is that the United States government, the United States military, was sharing intelligence with the Taliban. It found itself in a position during the Afghan Kabul airlift, the cause of which was the fact that the Taliban defeated the United States and its proxy government in Afghanistan, causing tens of thousands of people to flee. It had to share information with the Taliban in order to ensure that the Taliban would secure the airport from threats by even worse people than the Taliban, ISIS, Khorasan province. And you'll recall how many such instances probably were stopped, but one such instance was not, causing some 200 people to die in the attack at the airport. And in order to prevent such attacks, the United States carefully, with mitigation measures, about which we can talk about later, shared intelligence with the Taliban. So this is something that states will do as part of, I don't know, a formal military alliance such as NATO, or they may do that as part of a long-standing military operation such as the US presence in Iraq and Afghanistan for years or even decades, or they may do it on a purely ad hoc basis, such as in the example that I gave with the Taliban. So really the question is, what does international law have to say about this kind of phenomenon? And the argument I sort of develop is that there are two basic ways in which international law can regulate these instances of intelligence sharing. The first is sort of less complicated, but also less frequent or perhaps less relevant. And that's the situation in which there are specific dedicated rules of international law that may prohibit some type of intelligence from being shared. One such example is when you have a treaty that is specifically regulating intelligence cooperation. And the most famous such example will be the Five Eyes Agreement, the UK-USA agreement, which, as you know, includes not just the UK-USA, but also New Zealand, Canada, and Australia. And one article of that agreement basically says, if you get intelligence through this agreement, don't share it without asking us first. So if a state obtained an intelligence product through that type of initial intelligence sharing and then did something with it, it could potentially violate treaty obligations towards its partners. Now, this is something that is very likely to be dealt with only diplomatically. It's going to be a very hush-hush exercise. It's not something that's going to be dealt with by any kind of court, in 99.9% of cases. The one categorical rule of international law that will, however, inhibit intelligence sharing in peacetime and wartime context, and that is amenable to litigation, is human rights law, and specifically the right to privacy. And depending on where one lives, that may either directly be the human right to privacy. For example, in the UK, where the right to privacy under Article 8 of the European Convention on Human Rights is essentially directly incorporated in UK law. Or it may be, in addition to that, or on top of that, a substrate of data protection law that has similar kind of purposes, but may also have very different sources, origins, like in the EU, and so on. Or it may be domestic privacy guarantees. So you may, for example, be in a possession of information that, if shared, is per se, the sharing per se needs to be justified in the necessity proportionality framework of human rights law. And so I discussed this sort of at length in the paper. If you want a good example of this, the best recent example of how the human right to privacy may regulate intelligence sharing are the two recent judgments of the Grand Chamber of the European Court in the Big Brother Watch case and against the UK, and the Centrum for Rättvisa something against Sweden, where Sweden in particular was found to have violated the European Convention because its domestic legal framework did not adequately protect the privacy of individuals whose information, whose personal data was being shared by an intelligence agency with its partners. And when you read that judgment and when you look at sort of what kinds of safeguards the European Court is asking for, 90-something% of states do not meet these requirements. They do not most likely have an adequate legal framework with sufficient independent oversight and safeguards that will apply to these types of sharing arrangements. I am sure, for example, Serbia does not. I am probably sure that Israel does not either. Now, your exposure to litigation, of course, and to risk of litigation will vary depending on where you live, right? If you're a European state, if you're Sweden, the European Court is just there waiting to be, invoked. If, however, you are Israel, you have less exposure to that type of risk. But nonetheless, you might be exposed to some different type of risk of a similar kind like litigation before domestic courts that is based on a variant of the right to privacy. So that's the first sort of type of intelligence sharing, of regulation by international law of intelligence sharing. Note that the right to privacy stuff will only cover a subset of all potential information that implicates privacy interests. There will be plenty of information, especially military operations, that implicates nobody's privacy interests. So for example, if Israel is sharing information with the United States about Iran's nuclear programs, that does not implicate anyone's privacy interests. But if Israel is sharing information about a particular nuclear scientist in Iran, and where they live and who are they friends with and who's their wife and who are their kids and what they do every day, well, that does implicate privacy interests, if you see what I mean. So the question is the nature of the information that is being shared. Some information simply does not implicate privacy interests. Okay, so that's the sort of easier part of international law when it comes to the regulation of intelligence sharing. The more complicated one, the one that I really devote most of my paper to, are these questions of complicity, where the problem is not the sharing of intelligence as such, or at least not necessarily only that, but the interface of that sharing of intelligence or the receipt of intelligence with the wrongful act of a partner. And basically, sharing or receiving intelligence may become unlawful, not because they're categorically prohibited, but because they're connected to the unlawful act of the partner. And here again, we have two basic scenarios. The first scenario, the sort of more straightforward one, is when state A shares intelligence with partner B that then facilitates a wrongful act by B, for example, torture. So the United Kingdom, I'm giving you a real life example. The United Kingdom shares information with the United States and with various other states that leads to the extraordinary rendition, arbitrary detention, and later torture of Mr. Belhaj and his wife in a prison in Libya. All the UK did was share information. And then there's a chain of other entities, states, who ultimately perpetrated a human rights violation or a series of human rights violations. So the rendition, the detention, the torture, right? So that's the sort of basic paradigmatic scenario. I am using torture here as an example, but it is a potentially misleading example because we are not here talking only about torture. It could be some other violation of international law. For example, the UK or the US or Israel, whoever, shares intelligence with a third state or a non-state actor, which it thinks may violate the right to privacy of somebody else, or may violate the right of a state, such as sovereignty through a cyber operation or a non-intervention, electoral interference, misinformation campaign, whatever, a violation of diplomatic inviolability of a person. So it's any rule of international law that's potentially implicated. I'm not focusing simply on like cases of torture. So that scenario of intelligence sharing assisting a wrongful act. A more complicated scenario in terms of dealing with these complicity type rules is when I'm state A and I'm receiving intelligence provided to me by partner B. And I know or suspect that the intelligence was unlawfully collected. So it is not, my receipt is not directly facilitating anything, but I'm obtaining information that I know, for example, could have originated through torture. The UK, again, these are real life examples, the UK receiving in hundreds of instances, as established by the Intelligence Security Committee of the UK Parliament, in hundreds of instances receiving information from the United States during the War on Terror that it either knew or suspected were obtained through the torture of detainees. Okay, so it's that type of scenario. And again, it need not be torture. It can be, for example, a systemic violation of the right to privacy. If a state is subjecting its entire population to unlawful surveillance without any safeguards and extracts that type of information from its people, which it then shares with somebody else, you have the same type of scenario. So that's really the two kind of complicity scenarios. And then what I do really in the paper is I try to unpack the various complicity rules that we have in international law that may regulate these two scenarios. In the process of doing that, when I started writing this, I thought this will be a more manageable task. And I did not set out to write a 60,000 word piece. Let me put it that way. It developed into a 60,000 word piece. And part of the reason why that is so is that a lot of the rules, as you'll see, that sort of we talk about in this context are under theorized, under sort of explained, with regard to one particular element of all of these rules, and that's the so-called mental or fault element of all of these rules. The first such rule, the one that is really probably the most important, certainly that's of a general applicability, is Article 16 of the ILC Articles on State Responsibility, which prohibits one state from aiding and assisting another. If it does so, I'm quoting from the text of the article, in the knowledge of the circumstances of the internationally wrongful act that is being facilitated. Now, this provision, which basically the ILC kind of made up, but which then gradually has become mainstreamed to the extent that in the Bosnian genocide case, the ICJ just said, this is customary law. And to the extent that few states today will disagree with that proposition, right? The problem with that provision is that it's a complete mess when you read the text of the article and compare it with the commentary. Whereas the text of the article talks, for example, about knowledge of the circumstances of the wrongful act, the text of the commentary uses several different formulations in a completely inconsistent way that seem to indicate some kind of further requirement or maybe not a further, but an alternative requirement of intent, without explaining really what they mean by that. And so I spent a lot of the article, and we do not need to get into this, but if you want to, I'm happy to, unpacking sort of these various different conceptions of intention in philosophical criminal law literature, for example, and how they could map out onto Article 16. And my basic argument is that Article 16 should be interpreted as including several different alternative modes of fault. Not just one, but a multitude, or at least three, okay? So that the first mode of fault would be that if a state acts with the purpose or direct intent, meaning with the conscious object of facilitating the wrongful act of another state, it will be liable for aiding and assisting. Regardless, and this is the key bit, regardless of what it knows. Okay? So for example, if I intend to kill Yuval, just because I don't like it, and I'm a sniper shooting from a 2-kilometer distance with some kind of gun, and I know there's only a 0.1% chance of actually hitting Yuval and killing him, but I nonetheless do it, okay? I hit Yuval and he dies. All that is required for my criminal responsibility is that I acted with the purpose to deprive him of his life. The fact that I thought it was 99% unlikely that this would actually happen is irrelevant. See what I mean? So if I act with the purpose of facilitating somebody's wrongful conduct, the fact that I think this may or may not happen, I'm not certain it's going to happen, is irrelevant if I'm acting with that kind of bad purpose, okay? Then I say, I argue, the second mode of liability that should be included in Article 16 is so-called oblique or indirect intent, which is that when I do not have the purpose of facilitating the wrongful act, but I am A, practically certain that my partner intends to commit that wrongful act, and B, I'm practically certain that my aid will facilitate the act. And I disregard that certainty and nonetheless provide the aid, okay? So the normal example given sort of for this type of oblique indirect intent is, I intend to kill Yuval while he's on a plane. And I do that by putting a bomb on the plane. I did not have the purpose of killing the 100 other people who were on the plane together with Yuval. Their death is of no consequence to me. I don't care about it. I'm completely indifferent to it. But nonetheless, I was practically certain that their death will result from my actions, and therefore I indirectly, obliquely intended it. And in the same way, I can be practically certain that my aid will facilitate somebody else planting the bomb on Yuval's plane. You see what I mean? So that's the second sort of type of culpability that I think would suffice. You can see here how the cognitive element is much more dominant over the volitional one compared to the purpose direct intent scenario. And the direct intent purpose scenario, it was irrelevant whether I was certain or was not certain that the wrong would be facilitated. Here, that's the key issue. Right? And then the third mode of liability that I refer is this whole idea of willful blindness, where I trying to shield myself from inconvenient information. I do that with the purpose of avoiding acquiring information, but for which I would have had practical certainty. Anyway, so that's the sort of basic argument that I make. Normally, if you look at the literature, one huge sort of line of argument against purpose-based tests is that such requirements are completely, unrealistic, that purpose cannot be proved in reality, and so on and so forth. And that's why, a big strand of the literature, for example, Miles Jackson and so on, argue for purely knowledge-based tests. But, as I explained in the paper, I think these concerns are largely exaggerated or overstated for a couple of reasons. The first reason is that normally, depending on the context, you do not have to prove these things to a beyond a reasonable doubt kind of standard of criminal proof. That is not normally the level of certainty you need. The second is that you can resort to inferences. And the third is that the courts in particular, if we're talking about judicial settings, courts do this all the time. So for example, the European Court of Human Rights has recently found Russia, Turkey, Azerbaijan, pick your state, of having acted with an ulterior purpose of suppressing political pluralism and dissent. For example, that Alexei Navalny is being politically persecuted. The European Court said that and inferred that from the evidence. It did not have to establish this to any kind of beyond a reasonable doubt standard of proof. Or just very recently, the European Court found that Russia assassinated Alexander Litvinenko, that Russian officials essentially instructed the two assassins to kill Alexander Litvinenko, and it did so entirely by inference and by reversing burdens of proof, and certainly did not do so to any kind of criminal law standard of proof. So that would be sort of my argument as to why purpose-based forms of liability are not something wholly unrealistic to implement. So that's Article 16. And I think this conception of Article 16 satisfies really what is the overriding concern with all of these complicity type rules, which is that on the one hand, having very loose culpability tests makes them over-inclusive and captures too much state cooperation that is potentially beneficial. On the other hand, very narrow culpability tests would make these rules under-inclusive and would leave out an enormous amount of cases that we intuitively morally feel would need to be categorically or would need to be captured by these rules. For example, a purpose-based rule might not capture the type of assistance that the Russian Federation has been providing to the regime in Syria, essentially to facilitate its remaining in power, while knowing that the regime would commit many, many bad things in order to remain in power. So that's Article 16. And this is a rule essentially that A, applies only between states, but B, applies across the board of international law, regardless of the type of violation that we're talking about, regardless of the nature of the rule of international law. And then in the paper, I look at two other parts of international law, IHL and human rights, that may have bespoke specific complicity rules, which have several added values or advantages compared to Article 16. One is that they will capture state assistance to non-state actors, and maybe even non-state actors to non-state actors, depending on how you wish to look at it. Article 16, as written, is a purely interstate rule. However, neither human rights law nor IHL need to have that purely interstate focus. And the second advantage of these rules might be that they have lower culpability requirements, lower but not higher than Article 16. So let me just very briefly explain. When it comes to IHL, as you all know, under Common Article 1 of the Geneva Convention, states have the duty to respect and ensure respect for the conventions. And the so-called external dimension of Common Article 1 has been a much debated topic, a very controversial topic. You know, this whole idea of, does the United States have to exert influence on Saudi Arabia to prevent Saudi Arabia from doing bad stuff in Yemen, you know? And some states, particularly the US, the UK, and Israel, for example, have been pushing very hard against that type of positive obligation. But that is not what I'm talking about. I'm not talking about a positive duty to prevent harm. Rather, I'm talking about the negative duty to refrain from harming, or specifically to refrain from assisting other people from committing violations of IHL. And there is much less controversy. If you look at the 2016 ICRC commentary, for example, on the Geneva Conventions, you'll see they expressly bifurcate the negative duty to not be complicit and the positive duty to exert influence. And this negative duty not to be complicit has been, you know, the object of, for example, the ICJ's analysis in the Nicaragua case 40 years ago, when it found the United States liable for encouraging violations of IHL by the Contras, by a non-state actor. So I don't think it can really be seriously contested that A, this rule exists, B, that this rule captures non-state actors, C, that it captures situations in which a state is not necessarily itself directly involved in an armed conflict. There is a world of difference between the UK or Zambia or, I don't know, Israel having to exert pressure on Saudi Arabia and a scenario in which the UK or Israel or whoever are selling weapons to Saudi Arabia. Okay? In the first scenario, the state is simply a bystander. In the second scenario, the state is actively facilitating violations of IHL. And it can do so through selling weapons, but it can easily do that by sharing intelligence or by sharing cyber toolkits and know-how. And so I would submit that this Common Article 1 duty to respect, essentially to refrain from assisting, is the key issue here, and it is not as controversial as the positive duty to exert influence. And my second argument is actually that the culpability requirement should also be lower. If you look, for example, at the Arms Trade Treaty, you will see the type of culpability requirement that I think can very usefully be employed here. And that's essentially a recklessness type fault element. The state, the assisting state, perceives a degree of risk that its assistance will be misused, and then it consciously disregards this risk by providing the assistance. So that kind of risk-based mode of fault is, I think, what's appropriate for serious violations of IHL. And essentially, I'm not going to bore you with this more. I make the same argument with regard to human rights law and serious violations of human rights law. If a state perceives a risk that a person may be tortured, for example, even outside armed conflict, it has a duty to refrain from assisting that activity. And as in any kind of risk-based mode of liability, if it nonetheless provides the assistance and the wrongful act happens and is in fact facilitated, the state is simply liable for complicity. If it gambled and gambled wrongly, okay, it will be liable. Now, I also cover many different issues in the paper that we may want to turn to in the discussion, but I have been talking for far too long as things stand anyway. The sort of two issues I will flag is one is this problem of perspective, which is that really a great deal depends on whether we are talking about a state's own officials assessing prospectively whether they can provide assistance. For example, a legal advisor in the foreign ministry has to clear the sale of weapons, or a legal advisor in the intelligence agency has to say, okay, can we share this intelligence? So that type of scenario. From a post facto scenario where the wrong has already happened, it has already been facilitated by the sharing of intelligence. And normally there is some third party, a court, a fact-finding mission, a UN special rapporteur, a parliamentary body, whatever, who has to subject the thing that has already happened to scrutiny and to establish whether the state's official acted with the requisite degree of fault. Okay, so that's the first problem. And the second really big issue when it comes to these risk-based forms of liability in particular is whether risks of causing harm through complicity can ever be balanced against the risks of suspending assistance. Look, for example, at the American sharing of intelligence with the Taliban. While they were sharing intelligence with the Taliban, the US knew that some of that information could be misused by the Taliban to find people whom they wanted to kill. Okay? Because they were fleeing from the Taliban. The reason why they needed protection is because that's who they were running away from. And so what the US was doing, as you can see from a statement of General McKenzie, is they were limiting the nature of the type and content of the information. They were implementing these so-called mitigation measures to reduce the risk. But the risk was still not zero, okay? There was still some risk that the Taliban would misuse the information provided and actually retaliate against the people whom they were supposed to protect, okay? Can, in that type of scenario, the United States say, well, look, yes, we knew the risk was not zero, but we still acted justifiably. We did it to protect more lives, okay? The reason why we shared intelligence to save more lives. And that's what justified our risk taking. So this is really a question of justification or balancing of different types of risks. And we can talk about it if you'd like. It's a non-obvious question. And in many criminal law systems in the world who use, for example, types of liability such as recklessness, frequently you will have either explicit or implicit justification tests that try to sort of somehow explain to judges or to normal people that some risk-taking can be justified. So I will stop here. And I'm very looking forward to our discussion, much more so than to me blabbing for half an hour.
Thank you very much, Marko. You actually presented exactly how you promised to do in the exact time frame. So it was wonderful. The floor is now open for discussion. If I may, by the way, the cat was quiet during the time that you talked. So if you're around, can I buy you a coffee? Tell me your secret. And more seriously, I was wondering, how would you differentiate between a situation where one state passes, sells, or delivers in any other context information in comparison to passing or selling the tool for gathering information? So, of course, the scenario which we think of is something in the line of NSO, black box, and etc. So how should we differentiate the discussion in this regard. First of all, the difference between giving someone the tool or just a fruit of the tool, but in addition also from the aspect of the relation between companies and states. Because what may constitute as a wrongful act for a state might not constitute a wrongful act for that company. So is this the same problem when we get to the complicity part? The second question is more from the direction of general international law. Our CIWA in general, the line is that the legal standard that is derived from the primary rule. Now, there have been several violations which have been mentioned, right? So torture, that's one legal standard. Privacy, that's another standard. If we deal with criminal law, in addition, that's another standard. How can we extract a general rule when we are dealing actually with the secondary norm, which is automatically influenced by its context? So thank you.
Thanks so much. Excellent questions. Forgive me. I am hungry and a bit tired. And when there's a whole series of questions, I may forget question one by the time I finish all the answers. Sorry about that. So repeat them if I'm being Alzheimerish. So let me start with question 3. You are right that, so some people say wrongly, I think, that international law has a problem with subjective standards, and that there is some kind of default presumption in favor of objective standards, like due diligence, which is really a form of negligence. But as you say, that's actually not true, right? I mean, what international law does, it leaves normally to any specific area to design its own fault requirements, if any. So there is really no need to look across the board of international for some kind of common approaches to what the fault standards should be. The only exception is Article 16, because you need, if you have a complicity rule that is generally applicable, you need to have a fault standard for that rule. And so that's why I suggest that tripartite form of that rule with really 3 alternative modes of fault that is neither too inclusive or too under-inclusive. But if you are discussing questions like a purely human rights-based complicity in violations of the right to privacy, what you need is a human rights analysis of modes of fault that essentially these courts never really clearly do for various reasons. And we can talk about it more if you'd like, but that's the question. On your first question was so good about the difference between sharing intelligence, sharing the intelligence gathering tool. So I would say there is no difference of principle. They are just like there's no difference in principle between sharing intelligence and sharing a weapon, like bombs. The difference will be in the ability to predict what the partner will do. Because all of these issues about either practical certainty, indirect intent, or serious risk like recklessness, they are really about a type of foresight. Will my partner do something bad with this? And will they misuse the aid I provide to do so? When you share intelligence, the nature of intelligence is that if it's relevant, it's going to get used. So in some way, your causality analysis is going to be simpler. If I know the Americans routinely torture people in the war on terror, as they have done, and I share intelligence with them that may enable the torture and rendition of a certain person, there's really, you don't need to overthink this. You know, when the UK shared information about Belhaj with the CIA, they knew there was a serious risk that he was going to get renditioned and arbitrarily arrested and may potentially even be tortured, right? So sharing intelligence in that sense is easier to do that type of foresight analysis than when you share a tool. Because you can say, okay, we're going to implement various safeguards in the tool. We're not going to tell them everything about to exploit these capabilities, and we will reduce the risk that it will be misused. And then we will implement safeguards if they misuse them. So the NSO not my favorite private company, right, in the world, did a good thing. Can you imagine? Which recently came to light. I don't know whether you have been following this, but a couple of weeks ago, the UK, the High Court of England and Wales published a whole series of decisions dealing with the Emir of Dubai and his litigation in the UK against his wife and the divorce and custody sort of dispute. And as part of that disclosure of these decisions, it came out that they used Pegasus. The UAE used Pegasus to spy on Princess Haya and on 2 British lawyers. And so, to NSO's credit, they A, kind of confirmed that to the British courts, and B, they suspended the contract with the UAE. Okay, so which is not something I would have expected them to do, but there you go. Okay, so that I think is a good example of what a company should do in these types of situations. Maybe they should have done it earlier, because if you know you're gonna, give that type of tool to an authoritarian country like the UAE, they're gonna use it against human rights defenders and civil society and so on. That was a very long answer to a very complicated set of questions. Sorry if I missed anything.
Thank you. That was perfect, and I'm actually glad. That was my line of thinking. The only problem, though, is that if we disconnect the causal link when we view the tool, then in a way we incentivize states to deliver the tool instead of information, which is riskier. But it is resolved by the example that you gave of NSO. So brilliant.
Yes, you're right.
Marko. So Yuval, please.
Thank you. Still recovering from this near-death experience from before.
What, reading the paper? Was that the near-death experience?
No, they are examples, my friend.
Right.
Yeah, so along the same lines of Tal, the issue of really what do you do with these situations where, harm is foreseeable, but at some level inevitable, in the sense that you are within the Five Eyes. You're in a counterterrorism platform, so to speak. You share information with your partners because you're on the same side and you want to effectively combat terrorism. But you always have this sinking feeling that, at least one of the 5, let's say, maybe we're thinking about the same one, may get some radical ideas as to how to deal with the threat. Not sharing the information would also be irresponsible because, the threat is real and you do want to neutralize it, of course, acting lawfully. But you always have the risk, and the same goes for, for when you give weapons, when you give these tools. So it's not unforeseeable, but then at some level, as I said before, it's practically, it's inevitable. You do mention in your piece, that you could think about exculpatory defenses, but I wonder whether they would, as you mentioned rightly, the conditions are pretty stringent. So the question is whether this is simply, a risk that states that cooperate with other states have to assume, or whether you have a way to factor in some of these strategic considerations in actually sharing information, and the fact that you discount the issue of motive, of course, gets you there to begin with, because of course the sharing state has no interest in this result happening. Do you want all 3 questions now, or do you want to take them given your state of famine?
No. Let's do this now. Otherwise, okay. There's no way I'll manage. But
maybe just another one which is a bit connected, and that's the issue of assurances. Because you do mention this in the paper, and I'm wondering, what do you make of assurances? And within the human rights ecosystem, there is a very hostile approach towards assurances. especially given the examples, you know, like torture. I mean, how can a state that is involved in torture ever give a credible assurances? And then I have something completely different.
Fab. So, I mean, these are all excellent. Your first question in particular, it really goes to this fundamental dilemma between over-inclusiveness and under-inclusiveness, which, as you say correctly, arises in numerous other contexts. I mean, the one that people are very, very familiar with is in the international criminal law context, which expressly uses, at least as customary law is concerned, expressly uses a knowledge-based standard for complicity. And you will all recall the so-called specific direction saga before the International Criminal Tribunal for the former Yugoslavia. So this arose in the case called Perišić against the former chief of staff of the Yugoslav army, who was supplying the Bosnian Serbs with all sorts of assistance, knowing that the assistance will be used inevitably, as Yuval put it, to commit war crimes, crimes against humanity, maybe even genocide, right? So he knew this. It happened so many times in the past that the aid was misused. It's not like he couldn't say, I didn't know this. But he was nonetheless acquitted by the appeals chamber on the basis that his aid was directed to the overall war effort and was not specifically directed to the commission of a crime. And essentially, they were playing with the causality, the causal contribution element of a complicity rule, which sits next to the fault element of a complicity rule. And the express reason why they did so, if you look at the hearings in that case, was one of the judges asked the prosecution, so does this mean that whenever Barack Obama provides assistance to moderate Syrian opposition forces, knowing that it's inevitable that at some point in time they will use this aid to torture somebody, detain somebody, that thereby Barack Obama becomes complicit in that crime, okay? And then the problem with this approach, though, is that there's simply no way, simply through this kind of causal analysis, that you're going to deal with the problem. What you're really saying, what you're really doing with it, is that you're turning the complicity fault standard into purpose. Okay, so in the end, after Perišić, there have been a series of other ICTY cases in which they said Perišić is junk. You know, we're departing from that. It was wrongly decided. Okay. So one way of dealing with this problem, Yuval, that you point to is really to slightly maybe elevate the causal standard, but the big thing, the deal breaker would be to say, no, we need purpose for accomplice liability. The problem with that approach is that it immediately is exposed as under-inclusive, that too many horrible situations like Russia assisting Assad will be completely uncovered by this rule. And so my bottom line is basically this: there is no way, no legally coherent conceptual way through which you will find an answer to this dilemma. The tension will always be there. There may be some things we can do to sort of try to kind of limit it. One thing that I think we can do, which I mentioned in the paper, is this idea of justification through, for example, either circumstances precluding wrongfulness or as part of a framework such as human rights law, especially in cases where human life is directly at stake. But if a state wants to earn billions of dollars by selling weapons to Saudi Arabia, then it is taking a risk that if Saudi Arabia uses this to drop bombs on people and kill civilians deliberately and so on and so forth, that it will be complicit. Right. And if the risk materializes, the state is complicit. And simply making money or achieving geostrategical goals, et cetera, cannot be justified, I would think, within the international legal framework.
Right, and you agree that asking assurances from Saudi Arabia wouldn't help you much in terms of
yes, exactly right. So I sort of, the allergy of human rights advocates towards assurances is a product of bitter experience of these assurances not working.
Yeah.
But sometimes these assurances do work. Like if Israel gives assurances to America on something, those tend to be complied with.
Right.
right? So I wouldn't say categorically assurances are worthless, but if there's a pattern of behavior that they're ineffective, then the state cannot rely on them.
Yeah. I think they got their bad name out of really torture cases, but I think there are other contexts such as immigration and economic condition, social conditions to migrant where they work.
And intelligence cooperation, where they're done all the time.
The other point I wanted to raise is our favorite topic about extraterritorial jurisdiction and the interplay with Article 16. And I guess, you have been following the recent Committee on the Rights of the Child decision, Sachi versus Argentina. Would you agree that, and well, you know where I stand, but given that this is the direction and this reasonable foreseeability is becoming like increasingly the touchstone, I'm wondering whether you accept that there will be very limited space, if any, between Article 16 and this notion of jurisdiction, because once you reasonably expect that something bad would happen as a result of your intervention, then you also assume jurisdiction. That is almost becoming again inevitable, like the inevitable consequence of foreseeing the harm.
I agree with the proviso that you don't need this jurisdiction stuff for Article 16 at all. You need the jurisdiction stuff only for a purely human rights-based kind of complicity. You cannot litigate, for example, Article 16 before the European Court of Human Rights. You cannot say, on the basis of Article 16, I'm invoking a state's responsibility. You have to show that the convention as such was violated. So, for example, if Serbia, a state party to the European Convention, shares intelligence with Israel, who is not a state party of the European Convention, and Israel tortures somebody, okay, that's not an Article 16 issue as such. It's a pure ECHR issue.
It's an Article 3 issue, but it will be litigated as an Article 3 issue.
Correct.
Where Serbia has made, like in the deportation cases.
Exactly. Well, yes and no. So basically, I agree with you completely that providing assistance is enough, as far as I'm concerned, to say that the convention applies. Essentially, you have an unrestricted duty not to assist violations elsewhere. The difference between the deportation cases, the non-refoulement cases, is that a human rights violation in those cases happens simply by exposing the person to risk. The moment you deport somebody to the risk of torture, even if they're not tortured, you are liable. But in these complicity scenarios, the state is only liable if in fact the wrong occurs and is in fact facilitated. See what I mean? So that's the big difference with non-refoulement. Non-refoulement is an inchoate rule, but complicity rules depend on the wrong being committed by the principal. Without the wrong being committed by the principal, they do not get engaged, if you see what I mean.
We'll continue this discussion some other time, because I think it actually underscores the point, but I'll keep silent now because others are already.
Thank you. Gadi, please.
Hi, thank you for the wonderful presentation. I have a question. Would you differentiate between false data and true data while intelligence sharing? I would guess that countries lie to one another frequently. Good families do, so countries should do this. And when you give a lie, the possibility that it may be used, it becomes sometimes even more apparent than true data. But it's false in a sense. How would you create this kind of causal link, which is at the threshold of some sort of charge? I remember from my history lessons about the Russians lying about Israeli troop movements prior to 1967, creating a war. Would that make them blame accomplices for a war? So I would like to know how, if you differentiate the two, and if so, how.
Well, thank you, Gadi. That's an excellent question. I mean, again, I think we look at several sort of different types of scenarios. I mean, the one thing I can say is that unless they have committed via a treaty, for example, that they will share truthful information with some other state, simply sharing false information is not as such a violation of international law, right? There needs to be an obligation to share the truth for that as such to be an international wrong. And you may well have this as part of these intelligence sharing agreements, normally secret, right? So Five Eyes is the most common example that is sort of public, but if you have a secret treaty that promises then you deliberately feed false information to your partner, the partner will say you're violating our treaty. The other scenario would be this. For example, state A gives false information to state B that state B then uses to pursue a drone strike. And it turns out that the people targeted by the drone strike are civilians, they're not military targets. Okay, so that's probably like the most kind of realistic type of scenario. And here, the real problem is really, how does international law deal with these mistakes of fact? And it's actually a complicated set of questions. I mean, think of, I don't know, Iran shooting down the Ukrainian airliner over Tehran, thinking it was a US aircraft, but shooting down a civilian airliner. The Russians probably shooting down MH17, thinking it was a military aircraft, but really shooting down a civilian plane. You know, the Americans' final action in Afghanistan was killing a US aid worker and his family, I think 8 children in total in the area, because they falsely believed, on the basis of information somebody gave them, that he was ISIS, right? So that's the type of information. And the short answer I can sort of give you is that neither is a matter of IHL, nor is a matter of human rights law, is a state always going to be liable for acting under mistake. If it took all precautions, but nonetheless made a mistake, it will not have violated either IHL or human rights law. The leading case on this in human rights terms is McCann, where the UK police in Gibraltar killed a bunch of IRA terrorists thinking they had a car bomb, but there was no car bomb. And they were completely unarmed. And the European court said this was not a violation of the right to life. What was a violation of the right to life is that the operation was poorly planned. But even in a well-planned operation, mistakes happen. So that's my long answer basically to your question, that simply acting on the basis of false information, especially if it's provided in good faith, is not ipso facto illegal, but it can be illegal depending on whether all precautions were in fact taken to verify the information, to act on the basis of that information, and so on and so forth. And then there's a third scenario, which is where you are receiving, sorry, I got confused. No, this is everything I want to say. I'm sorry, I got confused. So this is me. But excellent question.
Thank you. Elad, please.
Hi, thank you, Mark. It's fascinating and a very consequential topic, obviously. I have one question. I hope it doesn't take us too much off topic. You talked a lot about the legality of sharing information, and I want to ask you whether in some circumstances there can be a legal duty for a country to share information. And I think that this question arises in 2 different scenarios. So the first scenario is state to state. Let's say that, for example, Israel come to learn about vulnerability in a critical infrastructure facility in the UK. And it also knows that an adversary of the UK also learned about that vulnerability, and it might be put the UK in a serious danger of a catastrophic harm. Israel have a duty to disclose that information to the UK government, maybe its immediate interest is to keep that information to itself so it can use it against its own adversaries. But I wonder if you can establish under any kind of law, any body of international law, duty to disclose that information to the UK in this circumstance. And the second example, or a second scenario in which this question arises, is between a state and a private actor. And again, for example, let's say Israel or the United States knows about a software vulnerability in a Microsoft product that if others come to learn about, can cause huge harms all over the world. Does it have some kind of legal duty to disclose that information to Microsoft to have that vulnerability patched by the company?
Thank you so much for that, Elad. Can I, by the way, I started smiling at one point because it is so rare to have an event of this kind where every single question is like a superb question to such an extent that, you know, you can write an essay about only that question. See what I mean? Thank you so much, everybody, for these superb questions. So, Elad, on your two scenarios, the second one is slightly easier than the first, because when it comes to threats, in particular to private individual or entities or companies, there is a body of law that routinely imposes a positive duty of protection, and that is human rights law. And let me give you a concrete example so that we you know, forget cyber for a moment, even though cyber is all of our thing. The murder of Jamal Khashoggi. So Jamal Khashoggi being killed by Saudi Arabia in Istanbul. The United States may certainly had some information that there was a risk to his life by Saudi, okay? The UK may also have had some of that type of information. Now imagine that information reached the threshold that we normally require in human rights law, awareness of some kind of serious risk to the life, to an imminent risk to the life of an individual. Did, at the very minimum, the United States, the UK, or whoever else was in possession of that information have a duty to warn Jamal Khashoggi of what was about to happen to him? Okay, so that's the type of scenario. In your cyber example, massive cyber attack that can destroy a hospital or disrupt a hospital, or power supply or whatever that can cause harm to hundreds of thousands of people.
So that applies only when the harm reaches some kind of threshold of imminent threat to life?
Yes. Well, yes and no. So the duty of protection is generally overarching, but it has certainly been applied to this kind of duty to act in sort of threats to life type of scenario. And the leading cases are, for example, Osman before the European Court of Human Rights. But you have loads of stuff in the Inter-American Court, in the Human Rights Committee, and so on. That's really about these types of issues. If the person is on your state's territory, there is no doubt that you have to at least warn them. And in fact, many countries are doing that. Like you will find reports of like Canada getting a guy off the street, a Saudi dissident, because they realized there was an imminent threat to his life. And at the very minimum, informing him about what may happen to him, issuing these types of warnings. So that's a human rights type analysis. You see what I mean? The big problem in the Khashoggi case, or in the example you gave, is this extraterritorial dimension, that the person is outside the territory of the state that's in possession of the information. And this is a very long story. But it raises all sorts of problems of when are states supposed to help others? Like, is Israel supposed to vaccinate Palestinians? Is Israel supposed to share vaccines with people in Fiji? You know, it's the same type of kind of problem of positive duty of providing assistance. And there have been all these recent cases that if you're interested, we can talk about later on. So that's the human rights analysis that you can also apply to harm to corporate entities. The interstate issue is more complicated. Because normally there is no duty to help other states as states. Unless you've assumed it via treaty. Again, you might have an intelligence sharing arrangement that will say, and you have a duty to share information that might threaten our fundamental needs and national security, then it's easy. But there is no duty to be a good Samaritan as such. There is, however, this potentially complicated issue of whether you can be complicit in the action of some other state by omission. And this is also a complicated question in domestic criminal law. Like in domestic criminal law, imagine I'm a security guard, okay, in a warehouse, and I leave the warehouse unlocked when I go for my break. The thieves come in and they steal stuff. Okay, I failed to act. I failed to do the duties that were incumbent on me as a security guard, to call the police and so on. But complicity by omission is something the ILC expressly excluded from Article 16, rightly or wrongly, and is much more controversial than assistance through positive action. So this is a very long-winded way of saying that in the first scenario, there is normally no duty to help.
Okay.
And it'll be very difficult to root that duty in like black letter law. Much more easier for human rights kind of things.
Okay, thank you.
Thank you very much. So apologies. Thank you, Marko. We have another question from Joachim, please.
Yes, thank you. I do have a question. You also used this example in your article in the introduction about sharing intelligence, well, with another state that conducts a drone strike. So more specifically, so like, to the US drone program. And I am thinking, well, my question is, should both states, both the assisting state and the receiving state, have the same standards of international law? So for example, the Netherlands in 2014, there was a case in the Netherlands now ongoing that they share intelligence with the US, which the US used that intelligence to conduct a strike in Somalia, which killed a few civilians. So yeah, should, of course, the Netherlands, they consider, I believe, drone strikes as unlawful, but the US, well, obviously they don't. So should both states, so my question, can the Netherlands still be held responsible, even though they share the intelligence, but the US, well, they consider it lawful?
Splendid. Thank you so much, Joachim. So if I may, so I did this version of this kind of talk a couple of weeks ago in Nottingham, and Joachim, you were there as well. So obviously you liked it, and it wasn't too much for you. So that's an excellent question. The short answer is no, they do not need to have the same view of what the law requires. In principle, certainly as far as Article 16 is concerned, they need to be bound by the same obligation, which is not the same thing as the same source. Okay, so for example, if you assist torture, you're all bound by customary rules against torture, but you may not be bound by the exact same treaties or whatever, you know, so you do not need to be bound by the same source of the legal relation. You certainly do not need to share the same view of the law. I mean, let me give you a concrete example. The US invades Iraq in 2003. The US thinks, probably, let's say, subjectively believes that it is acting lawfully. Nonetheless, on an objective assessment, and in the view of 99% of international lawyers, the invasion is unlawful. So if you're Turkey, Germany, whatever, whoever it is, Israel, I don't know, and you supply intelligence, you open your airfields, you allow refueling, you assist the invasion of Iraq, all we need is that you are objectively assisting an unlawful act. Whether you believe it to be lawful is your problem. In the same way that in domestic law, generally mistakes of law are not exculpatory, right? Generally. Now, you do, however, point to a really big problem, which is that in multinational military operations in particular, partners will be bound by different sets of rules. They will be subject to different constraints. They will have different views of what the law requires and so on and so forth. You know, European states, especially the Scandinavians, whatever, there might be much more human rights friendly, for example, than US soldiers would be or whatever. The reality of things, though, is that even though you're not, if you're acting in this kind of multi-partner coalition or something like that, even if you're not bound by the same rules, or you are not subject to the same scrutiny because you don't have a court watching over you all the time, the higher constraints that sort of are imposed on some partners will tend to seep onto the other partners. They will have no choice but to take them into account because there's no way to do business otherwise. If you are cooperating with the Dutch and the British and the whatever, whoever, you know there's the European Court of Human Rights over them, and kinda you have to take that into account. And so that's inevitably what's going to happen in coalition operations. Willy-nilly, you know, the other partners sort of, if you're Australian, you have no human rights body other than the Human Rights Committee looking over you, you know, you still have to accommodate yourself to some extent to like what the Europeans are doing.
Thank you very much, Marko. It seems that we have heard all of the questions. If anyone else have a question and I missed you, please let me know now. Otherwise, I would like to first thank you from the bottom of the heart, Marko. We thank you, as you can hear. We've both enjoyed very much your presentation. We have to cut it out of the video later. We wanted to thank you. Apologies that we've postponed your lunch. And if you will share with us the information of the offices you're in, we will send you pasta, pizza, or whatever you wish. And thank you very much. I will also use this opportunity to introduce to everyone, we have a new research associate here in the Federman Research Center, Lior Zaks. Lior is a partner in the blockchain and cryptocurrency and head of the Department of Blockchain and Cryptocurrency in Porat Group, one of the biggest growing offices in Israel in this field. He also writes his PhD on digital development of autonomous organization, decentralization, and anarchism. We welcome Lior, and we wish him good research with us. And we thank Marko for this very interesting presentation. And we really hope to host you properly in Jerusalem next time, be that in our workshop or maybe in the International Law Forum. We have two possible avenues. So let's try and crystallize with one of them. So thank you very much, Marko. On behalf of everyone.
My great pleasure. Thank you, Tal, and thank you, Yuval, and thank you, everybody.
Until
Thank
next
you.
time.
Bye, guys.
Bye-bye.